Good morning and welcome to the PSPRS Continuing Local Board Training webinar series. I'm Robert Ortega and I serve as the Local Board Training Coordinator here at the system. I'm also here with Dawn Minear, who serves as our Local Board Training Specialist. We'd like to welcome both our in-house and online participants viewing this presentation today. We hope that these webinars provide you with useful information that assist in fulfilling your roles as appointed or elected member, local board secretary, or local board staff. We here at the system look to our local boards to ensure that they administer all the provisions of the PSPRS and CORP plans properly. Today's webinar will be a dual presentation. We'll be first presenting the 2013 legislation overview. We'll then transition to a brief update and review on procedures as it relates to processing and submitting forms and documents to the system. A quick note before we begin for our online participants. Throughout the presentation, we will take some time to answer questions. For those online, a text box should be appearing on your upper right-hand side of your screen. Please feel free to type your question in that box. If you do not see that text box, you should at minimum see an orange arrow in that same area. If you click that arrow, the text box should appear. These webinars are just one of several training tools that we provide to our local boards. Should your board have a particular training need or request, please contact myself or Dawn by calling area code 602-255-5575 or by emailing us at either rortega@psprs.com or dawn@psprs.com. I'll go ahead and now hand over the microphone to Dawn to take over.
Well, good morning. We hope you'll enjoy our 2013 legislative update. We have a few objectives we'd like to go over this morning. And with that in mind, again, if you have any questions, feel free to take those questions at a question and answer period in just a few minutes. The first objective we'd like to go over today is to review the current PSPRS initiated bills. In other words, this last year we actually initiated some bills to clarify some of the language that's in the law, and also some other bills were introduced as well. The other legislation that was affecting PSPRS, CORP, and EORP. And we'd like to make sure you have all the resources available to you and then answer any questions you might have as we go forward with this presentation. In the 51st Legislative Update first session, we do want to review with you that it's still currently in session, and some of the bills that we'll be talking about have passed and some have not, and they're still going through that process. But all bills will become effective on general effective date unless otherwise stated, which is 90 days after the close of the session on sine die. So in other words, some of these will have been signed by the governor but will be initiated 90 days after they close the session. The first one I wanted to go over is House Bill 2056. Then we'll review Senate Bill 1173 and Senate Bill 1174. Now, House Bill 2056 is actually the one that's in process now at the legislature right now. What it does, and is planning to go through as far as we know, but we wanted to give you the update on what this bill entails. Now again, I want to make sure you understand that it first of all clarifies when the subsidy for the health insurance and accidental insurance coverage would be payable. Now again, the process doesn't change anything. It just clears up and clarifies what happens with the subsidy payments. It also gives the system the authority to establish separate account that consists of the health groups and the accidental coverage benefits. And again, the subsidy only will be provided from the employer or from a state retirement system. So again, these are just some clarifications and gives the system some additional authority for the subsidy payments. It also provides clarification on the cancer insurance program, which we administer also for some of its administrative costs. And the reason for that is to make sure that all the costs are covered out of the cancer insurance program. And as local board secretaries, you're probably well aware that the cancer insurance program is well funded, and we want to make sure everyone has an opportunity to apply for that if necessary. It also, House Bill 2056 includes the joint powers of authority and the definition for eligible groups. And the reason this was introduced in the legislature this past year is because there may be some groups that might be coming together in a joint power authority situation and two different groups getting together, but they're still qualified as an eligible group within the plan. So we wanted to just make sure you're aware of some of the changes in House Bill 2056. Also, it includes additional confirming and technical language. Now again, this is a bill that we introduced, and we wanted to make sure it goes through the process just to not change the process, not to change the benefits, but it does help us in the office clarify some of the language. Now, in addition to that, we do have a part of the bill which defines the compensation to clarify the type of work which the pension contributions should be withheld and remitted. The definition of compensation doesn't really change, but it just helps our office clarify that on a per-case basis for those employees who have been working and contributing to the plan. It also does something a little bit different. It actually defines the physician in regards to the medical evaluations for the purpose for determining eligibility for its memberships and disability. In other words, a little more tightly written bill to add the language to define who the physician might be, you know, a medical doctor. Now, again, if you're planning on hiring somebody, they ought to go through a pre-exam to make sure they're qualified to work in public safety and define any pre-existing conditions and that type of thing, and it should be a medical doctor doing that. Also, if you may have a disability that comes up, we want to make sure the language is very clear that a doctor needs to see them as an independent medical exam in which they can now go forward and show the board the medical evidence of why that disability may have taken place with incident, perhaps if it's an accidental disability. It also prohibits the retroactive payments of any pension payments for a period of more than 180 days before the date of the person's application for benefits. Now, the reason why this bill was introduced also is to clarify the language. Previously, it was only 90 days, but now it's 180 days. That's a nice window in which benefits can be paid, but we cannot retro it back past the 180-day period now. And that's very clear as introduced in House Bill 2056. The other one we wanted to mention to you is it also clarifies the benefit payment to an eligible child that reaches the age 18. Robert, do you want to make a comment about that one?
Sure. I think with respect to this particular language, I'm sure as local boards are aware of, when there's situations and there is a surviving child benefit being paid out, specifically, you know, more on the public safety side because CORP does not have surviving child benefits. But in the language, it says that an eligible surviving child can continue to receive this pension payment up to the age of 18 or up until the age of 23 if they're attending full-time student status. But there was always this requirement that in order for that payment to be made, that individual had to be under a guardian or some sort of conservator, which created a lot of issues, especially for local boards when they were trying to make decisions on providing a benefit for this eligible surviving child, because under law, when someone turns 18, they're pretty much an adult. There's really no major reason for why they need to be under a guardian or under a conservator unless they were, you know, under a disability and are unable to function, or there was some extenuating circumstance where they did have to have some sort of guardian, legal guardian. But for the most case, you know, once someone turns 18, they are legally an adult. So there's been situations where those individuals, those qualifying children, wanted those benefits to be paid directly to them as opposed to being paid through some sort of guardian. So now this language kind of just clarifies that to define that once they reach the age of 18, if they still are eligible to receive this payment, meaning that they are attending school on a full-time basis and they're not under a disability and have to be under a guardianship with someone else, that they themselves would be able to apply for that specific benefit, the child benefit. So that's kind of where that language, why we put that language in there. So hopefully it will help the local boards deal with that situation, because we do know that there has been circumstances and situations where the local boards were having difficulties on on deciding whether or not they were going to award a child benefit directly to the child when that individual came to the board and said, I would like to receive this child portion or this child benefit directly in my name. So hopefully this will help you all as local boards to make those decisions, and now you have it in language and in statute that there is no specific self-guardian process where they have to provide all this documentation saying that they're their own guardian per se, because they're really an adult, and if they're eligible for this benefit, meaning they're on a full-time basis in school and they can provide that level of documentation to you all as local boards, then you should be able to move forward and provide them with that particular portion of benefit that they are eligible for.
Thank you. So you can see that a lot of these are just technical changes. They all help you clarify the language. And one other thing it does do, House Bill 2056, with regards to return to work language, it's been modified to give clarity to the local boards. Again, clarity meaning it just helps you move things in the right direction. If you do have a question, it clarifies return to work requirements. Again, the requirements have not changed, and we still do require that retirees cannot return to work with the employer they retired from in any capacity within 1 year, with a couple of caveat exceptions. Again, to review those, if the retiree participated in an open competitive process as a new hire for an entry-level non-supervisory role, then that person would wait a 60-day period. That is the one exception to the 1-year rule. The other exception would be if the retiree is hired as a volunteer, limited authority peace officer as defined by Arizona Post, or as an arson investigator or a fire inspector. There's no waiting period. So again, return to work rules still apply, but there's just clarifying language, as you'll see in House Bill 2056, to make sure everyone's doing this in the right procedure and the right process. So we wanted to kind of introduce House Bill 2056 to you today and let you know that it's going through the process with the legislature, but I don't see any holdups at this time, so you'll probably see this again being sent to the governor. The next bill that we'd like to review with you for just a minute is a bill in which it's called Senate Bill 1173. And this clarifies for the CORP, the Corrections Officers Retirement Plan. Again, it clarifies when subsidy and health accidental insurance coverage would be payable, and does the same thing as with public safety, so you can see that they're both the same as House Bill 2056. It gives the system the authority to establish a separate account that consists of group health and accidental group coverages. So we're trying to make sure the laws are the same in both public safety and in CORP when it's regards to the subsidy and the payment of that subsidy to the individual employer groups or to somebody who's within the state-run plan. And it also defines physician, as we talked about earlier. The CORP bill is very similar language. In fact, it's the same language to define who a physician is for these medical evaluations for hiring purposes or for any disabilities that somebody may apply for. There is one change in the CORP plan, House Bill 1173, and this does clarify that the eligibility for an accidental or a total permanent disability requires termination of the employment to be by reason of disability. So I wanted to make sure you're aware that as it is states in public safety, this is also stated in CORP as well. So in other words, somebody wants to retire for reason of disability, they need to terminate employment to be for that reason, the disability reason, the incident that happened or the why they can't work anymore. Another thing that I found interesting in House Bill 1173 is it again prohibits the retroactive payment of pension amounts. Again, going back to the 180-day period. Previous it was 90 days. So both public safety and CORP, there can be no more retroactive payments past the 180-day period of the date of application. So We wanted to make sure the language is the same in both, and you're aware of that today if you're working with public safety or CORP. It also, something a little bit different, removes the age requirement for disability eligibility review. It gives you, the employer, the local board, and allows you to review these up to what would have been the member's normal retirement date. In other words, you have somebody who's retired and they hadn't reached the normal retirement date. You can still review these disability applications, have them come back and see a doctor if necessary, just to confirm with the board that you're making payments to them in a benefit amount, and if you need to, that you can do that up to the member's normal retirement date. And again, it also clarifies the benefit payment to an eligible child that reaches age 18. We just had that discussion with public safety. You can see kind of the similarities between the two. The one that's probably some local boards aren't aware of, but it now requires anybody in CORP, a local board, has a need to meet twice a year now. This language is in public safety already, and it was transferred over to the CORP plan. So all local boards will need to meet, whether they're in public safety or CORP, twice a year, and we want those minutes, of course, sent into our office so we can review those and kind of keep on track of what you're doing. And our most recent newsletters have given you reasons why to meet and different reasons why you might want to meet more than just once. So now you know that it will be in the law that it's now mandating the local boards in both public safety and CORP to meet twice a year. It also includes additional confirming and technical language, just little words that help clarify and helps our departments here to run things smoothly. So that kind of helps you understand public safety and CORP are very similar in a lot of things that were changed. Again, these are technical changes. They do not affect anything to do with the benefit amounts. It just helps us administratively go through the process, and especially you local boards, all the local boards now have the same set of language in both public safety and CORP. Now we'd like to shift our attention to Senate Bill 1174. And again, I want to reiterate that both 1173 and 1174 have been sent to the governor and signed by the governor at this point, just waiting for the session to end to have its effective date. Now, this one does clarify the subsidy of health and accidental insurance coverage, as we talked about. It's the same in public safety as it is in CORP and elected officials plan. It also gives the system the authority to establish separate accounts for those health insurance and accident coverage benefits. 1174 also defines a physician. We've had a discussion about that, who the physician may be. It's very specific, and you want to be referring to your the laws as you move forward with any medical evaluations. It also clarifies the benefit payment to the eligible child that reaches age 18. And so all three plans have the same information. It also includes additional conforming and technical language, as we talked about before. So you can see we're trying to standardize all three plans to be administered in a very similar fashion. Now I want to mention here that there are other bills in the elected official plan that were presented and also approved. One in particular to have the court commissioner stay in the elected officials plan. We wanted to just kind of bring that to your attention as well, that it wasn't something that we initiated, but it's just a clarification of where the court commissioners will be, that there might have been other bills introduced as well. Now what we'd like to do is take just a minute and open the discussion for any questions, and then we'll discuss any other bills that are out there that are also affecting public safety, CORP, and EORP. So is there anything that you would like to bring up at this point from those that are here in our audience? Any questions of things that we've talked about so far with the bills that public safety has initiated for clarification for the language? Has that been helpful for you today? Okay. Any questions from those participants with the webinar? If so, as Robert explained, you can type those questions in. We're happy to take a minute and review those with you.
We do have a question from the webinar.
Okay, one
it's
question.
Regarding House Bill 2056.
Okay.
and it's asking if the return to work requirement only applies if the member is returning to work for a PSPRS position only.
I'll go ahead and take that question. As Dawn mentioned, the language itself or the requirements and provisions did not change. What basically happened with 2056 is the word basically did some wordsmithing, try to put it and present it in a way that is a little bit easier to understand for our local boards and our employer groups to understand the return to work provisions. But as Dawn said, they did not change. So just to kind of review that return to work provisions, when it comes to PSPRS, return to work is specifically dealing with the PSPRS retiree is returning back to work with the employer from which they retired from. That's basically what it comes down to. I am an individual who has retired from the City of Phoenix Police Department or City of Phoenix, and I am now returning back to the City of Phoenix. The language of return to work states this: that individual cannot return to work in any capacity, in any paid capacity, within 1 year. And as the language is now and the interpretation from the system is that any capacity is an any paid capacity, whether or not it is a covered position under public safety or not. It is any type of paid position within that employer. That 1 year, as Dawn stated, that 1 year provision does have exceptions, and those exceptions are, one, if that individual is returning back to a position that is an entry-level, non-supervisory position, and they went through an open competitive process for that position. If under those circumstances, that 1 year time frame reduces down to 60 days. And finally, there are no waiting period requirements if that individual is returning back as a limited duty, volunteer, limited authority peace officer as defined by ASPOST, or if they're returning into a arson investigator role or fire inspector role. So to basically answer your question, it's not specifically, when it comes to the 1 year provision, the any capacity, it's not specifically PSPRS covered position. It is any paid capacity with that employer.
Thank you, Robert. We do have one more question from the webinar. If you'd like to comment on this or if you'd like to pass, this is the question.
Okay.
Can you give us an update on the pending litigation that's been before the courts today from the legislation period of 2011? You know, there's been quite a bit of a few lawsuits that have gone back and forth, and would you like to care about that, or would you like to?
Sure, I can definitely weigh in, and I'm sure all of our employer groups are fully aware of what's been transpiring with respect to Senate Bill 1609, which went into effect in 2011, which is basically known as the Pension Reform Bill. With respect to the litigation associated with that, the two plans that are being litigated against are our elected officials' retirement plan and public safety retirement. At this point, there's no litigation associated with our CORP plan. But the litigation that is in play with respect to public safety, it's kind of in a holding pattern right now. There are basically two cases with respect to public safety. One for the retired members. There's a case where retired members out of public safety are suing the system with respect to plan provisions and specifically dealing with the permanent benefit increases, or what people commonly refer to them as COLAs. There's that case. And then there's the other case for the active members of PSPRS. And again, the provisions that they are challenging are, again, the permanent benefit increases as well as the contribution increases that are being had right now by our active contributing members. Those cases are on hold. What's primarily having a lot of action right now is on the elected official side, and that's kind of the reason why those cases are on hold, because the elected officials cases are pretty much the same. You have a group of retired members who are suing because of the permanent benefit increases, and you have a group of active contributing EORP members who are suing not only that provision, but the provision of the contributions as well. And those particular cases, there was a decision rendered at the Superior Court, and that decision was that they were unconstitutional, which obviously meant that the system was going to continue to defend it and appeal that case, and that case was appealed. And traditionally it goes through the appellate court system, but the Supreme Court decided to take those cases on and bypass the appeal process. There was a request made to do that, and they did approve that process. So it's not going to go through the appellate courts. It's actually automatically now being heard at the Supreme Court level. And those cases, I believe at this point, my understanding is I believe if not both cases, at least one of them they'll begin hearing that starting June. And so we're hoping that within the next few months, if not by the end of the year, there will be decisions that are made with respect to the constitutionality of those plan change provisions under 1609 for elected officials. And then obviously with those decisions in play, then obviously that would have some precedents and set some precedents with respect to the other cases regarding public safety and those plan provision changes, as well as CORP. So that's kind of where we stand right now with the litigation. Is a lot of the active litigation is primarily dealing with our elected official cases, and whatever is the outcome there is probably going to affect the outcome of any plan provision changes associated with public safety and CORP. And hopefully that answered your question.
Okay, we have one more question from the webinar. We appreciate your questions. This is the time to get those answered. Yes, please.
All right, this is regarding House Bill 2056, asking what is the definition of compensation?
Great question. As Don said, there isn't a major revision with respect to the definition of compensation, but as it will read once 2056 is approved and is enacted, which we anticipate would happen, the definition of compensation will read as such. Compensation means, for the purposes of computing retirement benefits, base salary, overtime pay, shift differential pay, military differential, wage pay, compensatory time used by an employee in lieu of overtime not otherwise paid by an employer, and holiday paid to an employee by the employer. Here's where the new changes come into play. For the employee's performance of services in an eligible group. That was a language change modification associated with 2056. The definition goes on further to say on a regular monthly, semi-monthly, or biweekly payroll basis, and longevity pay to an employee at least every 6 months for which contributions are made to the system pursuant to Section 38.843, subsection D. It goes on further to talk about compensation, talking about how lump sum payments are ineligible for considered compensation, how third-party payments are not considered compensation unless there are provisions with respect to those third-party contracts are between public employers and those particular situations, and then also talking about lump sum payments for sick time, holiday time, or any fringe benefits. The traditional, as I'm sure as you all are aware of, the traditional things that are not considered compensation. So with respect to the change in 2056, what that is doing is it's clarifying that the compensation that is considered pensionable and should have compensation or contributions withheld are strictly that compensation in which the services were rendered with that eligible group. And specifically, an example of that is you have, for instance, with our universities, we have university PDs. And so, they are an eligible group within our plan. So while they're police officers with the university, the services that they're rendering as a police officer, doing calls, et cetera, doing the overtime associated with that, is considered compensation and contributions should be withheld. However, if that individual also happens to be an adjunct faculty member and is teaching at that university, that is not services being rendered within that eligible group. It is services being rendered with the university, but it's not for that eligible group. And so, as such, that wage that's being earned for that teaching is not considered compensation, and so contributions should not be withheld. So that's kind of just the reason for that, is just to kind of clarify that any services that are being rendered that aren't specifically associated with the eligible group, the police department, the fire department, the fire district, etc., is not considered compensation.
Thank you. We have any other questions? We'll continue with the questions later then, if we don't have any from the audience or from the webinar at this time. We'll go ahead and move forward to a couple other bills that are affecting public safety, CORP, and EORP. Now, these are not sponsored by our office, but we want to make sure you're aware of them. House Bill 2204 has passed and been signed by the governor. House Bill 2562 is still in process, as well as 2608. Let's take the first one, 2204, House Bill 2204. This definitely affects public safety, and this has been a good change of something we've been needing for a while. This actually provides health insurance premiums to be paid to the surviving spouse of a dependent of a law enforcement officer that has been killed in the line of duty, if they are enrolled in one of these two programs, the insurance program provided by the employer or the insurance program offered by the retirement system. Now, the reason this went into effect is because this way we can actually pay an insurance premium, help pay a payment of a health insurance premium if they're killed in the line of duty. Also, the premiums are to be paid by the member's employer. In other words, this is a new law that actually the employer can pick up this cost if somebody is actually killed in the line of duty, which we think is a good thing. Also, the amount payable is the amount of the employer would pay if they had active coverage, as if the member was still working and not killed in line of duty, whether it be single coverage for the spouse or family coverage if there's children involved as well, a spouse and children. So it kind of gives a little more latitude. Before we weren't able to have those payment or premium payments paid, but now they are able to be paid by the member's employer going forward. Also, there's a couple of caveats to that. The payments may be discontinued for the surviving spouse of somebody killed in the line of duty if the surviving spouse maybe remarries or passes away or dies, and also if the surviving spouse becomes Medicare eligible, but at least they're being taken care of till age 65, and or eligible dependent no longer meets the qualifications as an eligible dependent person. In other words, this might be a child that might be involved in that situation. So we wanted to make sure you're aware of House Bill 2204. It's adding another benefit to those who are killed in the line of duty. The next bill, 2562, is in process, and Robert's been involved with this in many of the meetings. Robert, would you like to maybe take a minute and discuss this?
Absolutely. Before I move on to that, I just wanted to go back to 2204. Just to give some brief history, this bill actually, or this language, or this benefit, or this program, has actually been in place for a bit, but when it first was originally introduced, or the language that was originally introduced, had a limiting factor with respect to this program. So you had a member who was killed in the line of duty, and they had a surviving spouse or surviving children. What the language stated is that an employer had to pay premiums for that individual to have health care coverage if they were taking coverage through the employer or taking coverage through the state retirement systems. The employer was responsible for paying the premiums as though they were taking active coverage. As you may be aware, when an individual retires, for the most part, the retiree takes on the full burden of the premium associated with healthcare coverage. This program says that if there was a KIA, then the employer has to pay the portion of premium as though that individual was still an active member. So if you as an employer have policy set that when it comes to healthcare coverage for active members, you cover 80% of that premium and the employee is responsible for the other 20%, that is what this program is all about, is that surviving spouse or that eligible dependent, whatever level of program they're in, they would be responsible for the 20% portion associated with healthcare premiums, but the employer was required to make the payments to cover the other 80%. What happened with 2204 is it took away the limiting factor. There was a limiting factor with that program. It was only limited to 1 year that survivor or dependent could utilize this program. So now it took away that limiting factor altogether. There is no longer this 1 year waiting period. This survivor or this eligible child still is eligible for these type of payments as long as those exceptions don't come into play, meaning the surviving spouse remarries or dies, the surviving spouse becomes Medicare eligible, or the eligible dependent, if it's an eligible dependent receiving this benefit, no longer meets that qualification of an eligible dependent. So I just wanted to give a little bit of brief history on that 2204. I can give you a little status with respect to administratively here at the system. I know probably within the next few weeks, our insurance group will probably be doing some outreach to our employer groups to get a little bit more information with respect to their active member coverage and their premiums associated with that, because we would obviously need to have that type of information in order to calculate insurance subsidy accordingly. So just wanted to put a heads up to our employer groups who are participating today that I'm sure our insurance group will be doing some outreach here soon to kind of get a better understanding of active coverage associated with your particular group. So with that, I'm going to go ahead and move forward with 2562. As Don mentioned, this particular bill, while again it's not a system-initiated bill, we here at the system have been involved in the process with respect to the language associated with this bill. And this goes back, well over a year in terms of meetings and conversations dealing with this bill. For those groups who are online who may have been participating in those meetings, what this bill is all about, it has to do with ineligible members or those positions that do not meet qualification either under public safety or qualifications under the Arizona State Retirement System. And so there have been situations, and there are situations currently, where there are individuals who are in that particular circumstance. They don't meet the qualifications for membership into public safety. They then try to seek membership into the Arizona State Retirement System, and because of that employer group's particular 218 agreement, which is a Social Security issue dealing with whether or not Social Security is withheld and whether the position is covered under Social Security, they may not meet the qualifications to participate in ASRS, because that is a requirement to participate in Arizona State Retirement System, is that they are covered under Social Security and are mandatorily required to contribute to Social Security. So there have been situations where the position or the individual's position doesn't qualify in either plan, and so they're kind of in flux. And so this 2562 isn't clearing everything up. It's not. It's still a work in process, and this group that we've been participating with is going to continue to meet through the summer, even after the legislative session ends, to see what further modifications to language or whatever the case may need to be to address this issue will continue. But this particular bill is trying to hopefully address some immediate needs. And that immediate need is, where do these people go? Where can we put these individuals who don't meet the qualifiers in either plan? And so what 2562 basically does is it establishes a defined contribution system for those employees that do not meet eligible participation in ASRS or PSPRS. That defined contribution plan is going to be administered by the Arizona State Retirement System. So as an employer, as membership enrollments are being determined, and it is determined from the local board perspective that this position doesn't meet PSPRS qualification, and upon further investigation from the employer, it's determined that they do not meet membership eligibility and enrollment in ASRS, those individuals will then be required to be enrolled in this defined contribution plan. There are some stipulations or some exceptions on when they aren't necessarily required to contribute to that defined contribution plan, and specifically it deals in those situations where you have a retiree already from one of these plans, and there may be some other retirement program being offered to that individual, whether it's a 457 type of program, etc., specifically with that employer. There are some caveats within that, but again, probably within the next couple months, we'll be partnering with ASRS and hopefully providing a little bit more education to our employer groups with respect to membership eligibility as well as this new process. Language specifically dealing with PSPRS, though, I kind of want to highlight, deal with that membership determination. As you all are aware, local boards make those determinations. They make determinations on pension benefits, but they also make determinations on whether or not the position meets qualification to contribute to public safety. And while that's always been a requirement, we wanted to put into language, or it was requested that language be put in to kind of codify that and really make some explicit requirements, not only from the local board perspective, but also from the employer, to ensure that the local board has all the necessary information they need to make a membership determination, because we do not want to inadvertently misenroll an individual into the systems, because that creates a lot of havoc, not only for the systems on disenrolling these individuals, but it also creates, employee relation issues with that particular employee, where you as an employer may be stating that this person qualifies for public safety, but technically they don't. So it's important that the local board has all the necessary information to truly make that decision on whether or not it qualifies for public safety. And so the language in 2562 kind of just deals with that. It requires the local board to request and receive from the employers and members information needed for action on claims for eligibility for membership, and forward that information to the Board of Trustees. Again, nothing that doesn't already or shouldn't already be happening. Local boards should still already be making membership determinations, and that information comes to our system and we review it to ensure it's in compliance. But it's now kind of adding some additional requirements from the employer perspective. And specifically, that requirement is as such. When it comes to the necessary information that a local board needs to make a membership decision, the employer is required to provide the following information, or the information should include: 1, the date the employee was hired or appointed into the position; 2, the employee's position title; and 3, a good description of the essential functions for that position. If the local board is receiving all of that information, they should be able to make a proper membership decision, meaning it is a full-time certified peace officer or firefighter who is regularly assigned to hazardous duty, and all the components required under membership criteria. So now in the statutes, it's really explicitly stating that the employer needs to provide all of that necessary information, and the local board should be requesting all that necessary information to make a membership decision. How the local board partners with the employer group on processes associated with that is left to the local board. How you want to set your procedures and processes is left to the local board as normally. Local boards do set up their own policies and procedures on how they adjudicate claims. So how you partner with your employer group to make that decision is left to the local board and the employer group. But do note that it's important that all that necessary information is being provided to ensure that we do not have misenrollments. because it has occurred. It hasn't occurred a lot within public safety. I do know it's probably a bigger issue with respect to the Arizona State Retirement System, but we still want to make sure that it's not happening here at the system. And there have been some positions and individuals who have been identified at this point that are misenrolled, but with respect to those individuals, the systems are we're kind of in a stand down mode as we continue this process of really figuring out this total picture and figuring out where these individuals should be and how to address it. So at this point, we're kind of in a stand down mode, and we're not going to be kicking individuals out who have been misenrolled at this point. The language does state in the statute that after this effective date, we would be kicking those individuals out once we identify who they are. But for the individuals who are currently in these situations, we're kind of in a stand-down mode. So that's 2562. I'm going to go ahead and kick it back to Don, and he can finish up the rest of the legislation.
Okay, another bill that is in process, is not passed the House and the Senate yet, but it's going through the process, is a bill that's affecting the elected officials' retirement plan. We want to make sure you're aware of it, but it actually closes the EORP plan to any new members hired on or after January 1st, 2014. This is a huge impact to the elected officials plan. These are all the judges and those elected officials throughout the state of Arizona. What will happen is all of the new hires are placed in a defined contribution plan with a disability program administered by PSPRS. So not only does it not have a defined benefit plan where they work for 20 years and get a certain benefit amount, but they'd go into a defined contribution plan, so whatever their contributions are, they would have at time of retirement. It's a little bit different plan. This is still going through the process with the legislature, but we wanted to give you an update both in public safety and CORP to have you aware of that if you had anybody in that situation. So that'll be an interesting one to watch to see if that goes through the process within the next few weeks. So we wanted to not only mention that about EORP, but do we have any questions about those other bills that have been floating out there that we've not personally initiated, but any other questions from the group here today? How about from those who are on the webinar? Okay. Let's go ahead and go back to this. The question is?
Okay, we have some questions on House Bill 2204. The first is, if the surviving spouse elects the insurance by the retirement system, how does the employer pay for that?
I'll go ahead and take that question. This is Robert. That is a great question, and I actually have been talking with our insurance group, specifically Annette Jorgensen, who is our manager of insurance, to kind of figure that process out. And like I mentioned before, they're kind of figuring out the policy and procedure and going to be doing some outreach to our employers to get information with respect to active member coverage, and that's where that issue is going to come into play, because at this point we traditionally don't collect that information. And so if a survivor is deciding to elect the state coverage because they are eligible to do so, obviously we would handle the administrative aspect of that, because we do that right now currently for all retirees. But now we have this new process to say, okay, well, now we need to know how much of a percentage traditionally, or fixed amount, whatever the policy is with the employer with respect to active coverage. We need to know that. We need to know how much the employer traditionally pays, and is that process going to be that you as the employer are going to be required to pay directly that amount to the survivor, or how it's administered in partnership with the system? Those are still being worked out. I wish I had a specific definitive answer for you right now, but at this point I really don't. I think our main concern right now is to do this information gathering, because that's going to be the key point, is the information gathering, figuring out these premiums and the costs associated from the employers to one, make calculations with respect to subsidy, and two, to figure out, administratively, how is all this going to be handled. I'm probably confident that our insurance group will probably take a stance that it'll be the employer's responsibility with respect to the payments. So, if you figure out, okay, or if you have a policy that you pay 80% of active premium coverage, well, then what we'll probably do with respect to an individual who is enrolled in the state system, we would say, okay, this is how much the premium is for the state system employer. You need to pay 80% of this directly to the survivor, and we will attach the necessary subsidy for whatever level of coverage they're on their pension payment, and we'll withhold all of the premium from the pension, but you as the employer are going to be required to do, quote unquote, like a reimbursement of the costs that you should have covered as the employer. I'm thinking that's probably the route that they'll take, but please do not quote me on that. I know that the insurance group is still working through that process.
Any other questions from the group here or from the webinar? Two more questions. Okay, let's go ahead and take the first question, please.
This is regarding House Bill 2204. The question is, does House Bill 2204 require the employer to pay health benefits for the family of an officer who is killed in the line of duty?
Great question. It does require that. If I do, I'm pulling up the fact sheets as we speak. The language requires that the surviving spouse or dependent be enrolled in either the employer's health insurance program or the state retirement system from which the surviving spouse or dependent is receiving benefits. So in order for this payment or this process to be in effect, yes, you as the employer need to offer that coverage to that surviving spouse. They are entitled to be offered that coverage. If in policy, again, don't quote me on it, you'd have to probably work with the insurance group to get a clearer definition. But if in policy, traditionally you don't offer any type of retiree type of insurance or these type of programs, there could be a situation where you as the employer don't necessarily have to offer the health care coverage, but we know from the system perspective, we offer it to everyone. So if they take our coverage, you as the employer are still on the hook for paying the percentages or paying the cost associated, again, with active coverage. So I don't know if it explicitly states that they must have or must be offered employer coverage, but regardless, if they're taking our system insurance, you will still be responsible for the cost of active coverage. I know this is kind of a hot button issue with some of our employer groups, and it's important that you, as employer groups who are participating today, work with your legal counsel to get some clear guidance on that. Because again, this isn't a bill that's administered or initiated by the system, but we are just as inclined to put in effect the provisions just like the employer is. So it's going to be a partnership on both regards, because this wasn't a bill that was initiated by the plan, so we don't have all the answers on the intent and what the requirements are.
Any more questions from the webinar?
Yeah, we have another one regarding House Bill 2204.
Hot button issue today.
Yeah. The question is House Bill 2204 retroactive for older line of duty deaths?
That has been another question that has come up recently, and our response to the question is this. The bill itself had no retroactive clauses. It had an emergency clause, so the moment that it was signed by the governor back in April, I think it was like April 5th or April 6th, the law is in effect now. So it's an emergency clause that was in effect now. So anyone who's in that situation now is covered by the provisions. Whether or not that is a retroactive back to when this bill initially came in place, because, like I said, this program was kind of in place, I want to say, for a year, almost two. Whether or not it retros back to when this first was put into place or whatever, there's nothing in the language that states that. So we can't tell you from the system perspective that you must retroactively cover these individuals who do qualify under this language. Again, my recommendation is work with your legal counsel, speak with your legal counsel, and get their guidance on what might be the best practice. All that we can tell you is that the law is in effect now, and those individuals who are qualify now are eligible. Because I know that, again, previously it was a one-year time frame. Once that one-year time frame ended, this program and this coverage was no longer available to them.
Okay, this has been a good, healthy discussion today. Thank you for those questions. What we'd like to do now is, we have two more questions.
Looks like we have some more questions coming up.
This is regarding House Bill 2204. How does the employer learn whether the surviving spouse has remarried or died?
Great question. Sounds like you need to establish some policies and procedures with respect to whether or not that situation occurs. I'm sure from the perspective of if that individual takes the state coverage, I'm sure our insurance group is going to set up some policies and procedures on notifications and audit, quote unquote, with respect to that. But when it comes to the employer perspective, if they're taking the employer coverage, I think it's probably good practice now to set up some policies and procedures on how you're going to manage that process.
Okay, this next question is regarding House Bill 2562.
Okay.
The question is, you mentioned that some groups are meeting to work on the language of House Bill 2562. Which groups are participating in those discussions?
Well, the language of 2562 at this point, we're not anticipating any additional amendments or changes to what the current bill is at this point. So if this is passed and does go through, which we're pretty comfortable it probably will, the language is as is. With respect to the meetings beforehand and the meetings afterwards, it was a conglomerate of individuals. It was representation, again, from the systems, so PSPRS, myself, as well as our Deputy Administrator, Jared, representatives from the Arizona State Retirement System, and then also from all of our different constituent groups. We had representations from the League of Cities and Towns. We had representation from the different employee groups, from fire and police, and actual municipalities participated. I believe we had representation from Peoria, representation from Avondale, and then we also had a representation group from the counties, representing the county groups. So it was a pretty large group. I recommend anyone who is part of a municipality, a city, or a town, contact the League of Cities to get a little bit more information with respect to how all of this affects employer groups. But we wanted the state. This again it was kind of put into effect from the state legislature. So we've been partnering with the legislature on this whole process. So anyone who's interested in learning more about it, I would recommend that you contact your representative groups, whether it's League of Cities, whether it's the county groups, whether you're an employee group. There has been a voice at all the different points.
We have one more question from the webinar, and then we have another question from the group who's attending in person. Go ahead from the webinar, please.
Is there any language for PSPRS eligibility making contract school resource officers eligible to pay into PSPRS? Those individuals are working in capacity as fully sworn and uniformed officers, but are not eligible for PSPRS.
And at this point, there has been no discussion with respect to that. So at this point, they still would not be considered members into PSPRS because that individual must be an employee of an eligible group. And in order for them to be an employee of an eligible group, they cannot be on contract. In fact, our language right now says an individual who is paid on a contract basis is not considered an employee and not considered a member. So even for the school resources, they would have to be part of an eligible group within that's defined in our plan, and school districts are not defined as an eligible group. So.
Okay, thank you. The question from the group that's attending here, go ahead.
So regarding HB 2204, regarding the surviving spouse remarried, do they still have the option to keep their insurance through us or their employer and pay for it themselves, or do they totally have to get out of the plan?
Okay. Okay, so the question is does the surviving spouse get kicked out of the plan once you remarry? That's basically what the question is. Or do they have options? Do they have options at that point?
Well, great question. I know from the state perspective, when it comes to the state retirement systems and the plans that we offer, as long as the individual is a member of our plan, meaning that they're a retiree receiving a pension, they can continue to have coverage under the state retirement plans. They would no longer be eligible to receive that portion of payment that's required by the employer, but they can continue to be in our retirement plans. With respect to the employer groups, I would say that's probably left to the employer groups and how they set up policy procedure and through the assistance with their legal counsel, whether or not if they do remarry, can they still at least continue to maintain health insurance and pay full coverage without this payment being made by the employer. That I think is probably going to be left to the employer's decision.
Thank you. We appreciate all the questions. This has been, again, a healthy discussion. We'd like to move on with our presentation at this point and move forward and let you know about additional resources that are available to you to not only track the research and track the legislation initiatives that we've talked about. Now, again, there's been many other bills that you can actually view. Public Safety tracks the relevant bills and posts them regularly to our website, and we've given that to you. The other bills, you can view those as well and see how those have been tracked. If you want to look up any specific bill, you can search the legislative initiatives through ALIS, and this is a way to find that by keyword, by subject, or by legislature based off of the information, because we're still in process of many of these bills. Just a few of them have passed so far. Or if you ever wanted to watch the live broadcast at the Arizona Legislature, this is the link in which you're able to do that. Now again, all those who are attending the webinar today, we'll send this information to you in a packet so you can review it and continue to make notes and find these relevant additional resources available to you. Now, we do have contact information here in our office. As you know, myself or Robert Ortega, as we talked about, are more than happy to help field any questions that we're able to help you with this. And we have our online resources at PSPRS, and you can choose the plan and go through that process as well. So we appreciate those who've been here and the healthy discussion, the questions that have been asked. Again, not all the logistics or processes, as we are aware of, have been fleshed out yet, but they're still in process of making sure each of these bills will be implemented as they get passed with proper due diligence that need to be made. So we appreciate those who have been here today, and thank you for attending. We hope you don't sign off right away, because we'd like to go ahead and start the second part of our presentation for those local boards who may be not aware of some procedural changes for 2013, and give you an update on that.